So, we've talked now about how adults who suffer brain trauma can be deemed catastrophic. And you'll recall that I said that the test is different for children. So, let's now look at what happens if there is a child, so someone under the age of 18 years, who suffers a brain impairment. And it is a different test that will apply to them rather than the Glasgow Outcome Scale. It is the King's Outcome Scale for Childhood Head Injury, the KOSHI, KOSHI, that was adopted for use with respect to children. And again, this applies for collisions that happened June 1 or later of 2016. So the GCS score is no longer to be used with children. So there are 4 requirements. It's really a 4-part test when we're dealing with children. So number 1, the insured person must be under 18 years of age. Number 2, the insured person must have been admitted to a hospital as a result of the collision-caused impairments, and an actual admission is required. So not just they attended at the ER, there must have been an admission to the hospital where they had to remain. Number 3, and similar to the test with adults, there must have been positive brain imaging. So same thing, an MRI or a CT scan or some other diagnostic imaging that depicts positive imaging of brain impairment. And then 4th, the King's Outcome Scale, or the KOSHI, would apply, and there must be either a vegetative or a severe disability under that scale. This is the KOSHI scale, and you can see the items that are highlighted in yellow are those that will allow for a catastrophic determination. So number 1 category is death, which obviously wouldn't apply if we're dealing with catastrophic. So number 2 is vegetative, and what we're looking at here is very similar to what we looked at on the GOSI scale. Someone who breathes spontaneously, but there's no evidence of verbal or non-verbal communication, no response to commands. So think of what you understand to be, someone in a vegetative coma or on a feeding tube, that sort of thing. And then the other category is the severe disability, and there is a 3A and a 3B category. So 3A would be the individual is conscious, totally dependent, may be able to communicate, but requires special educational and rehabilitative settings. And then the B would be the individual can only do limited self-care, is predominantly dependent, may have meaningful communication, but again requires that specialized educational rehabilitation setting. So it is just these individuals who will qualify for catastrophic determination. And again, with children, it is similarly the functional outcome that is deemed to be important. And when comparing the child to what they should otherwise be able to do, it's important to compare the child to a child of similar age. So, if the child's not toilet trained, you would be comparing the child to someone else of the same age. And if that age is also not toilet trained, that would not be a functional impairment at that point in time. And the child will be deemed to be catastrophic if they meet those levels of impairment at the various time periods noted here. So at 1 month, they're vegetative. At 6 months, they meet category 3 severe disability, or if at the 9-month mark, the child's function remains seriously impaired, such that they are not age appropriately independent and they require ongoing supervision or assistance that wouldn't otherwise be required for their age. and that needs to be required for the majority of the child's waking day. So it's a little bit more lenient with children, but not too much. It is still very much a focus on the functional outcome. Now, I want to move on to the 55% test and how that test has been modified. And you can see highlighted in yellow the two main modifications. First is you can include a mental or behavioral impairment, but you are to exclude a traumatic brain injury from the assessment. And that is one difference, because what happened often is there would be double counting where the traumatic brain injury would form part of the physical assessment in terms of the brain impairment, but also part of the psychological assessment in terms of, the memory difficulties. And so when you're combining the physical and the mental impairment, you are now directed to exclude the traumatic brain injury from the mental or behavioral impairment and only include it on the physical side. The other change is that they have moved from the 4th edition to the 6th edition of the AMA guides. And so this, unfortunately, is going to make it more difficult for people to meet the test. It is a much more stringent test under the 6th edition. And so again, the 55% still exists, but it is a modified test. So let's talk about the key features of this modified test. So the 4th edition is used for all bodily and brain impairments, whereas the 6th edition is now used for mental and behavioral impairments. So now we've got to use both. So when you're assessing the physical impairment, you're looking at the 4th edition, and when you're assessing the mental and behavioral, you're looking at the 6th edition. And when using the 6th decision, you can only include symptoms and functional changes that result from the mental disorder, so from the psychological injuries and not from the brain injury. And so again, that is a modified test. Now, when we're rating the mental and behavioral disorders with the 6th edition, the end result is really a reduction in the cases that will classify as catastrophic. When you look at the numbers and how they are rated in the 6th edition, it in essence means you really need a physical impairment rating of at least 47% in order to meet the 55% threshold. And this is often very difficult to get. Typically, in the prior regime, you would see people with physical ratings in the 30s and mental and behavioral ratings in the upper 20s, which would then result in that 55%. That is now going to be much fewer and far between with the new rating system. The other modification is the marked impairment. And the way the test was modified here was to increase the number of marked impairments that are required. And you'll recall from that Pastore decision that I talked about, the insurance industry was pushing to require more than one marked impairment. Well, the government has now determined that 3 marked impairments are now required. And that was inserted in the legislation. So remember, there's 4 categories or areas of functioning that are assessed. At least 3 of those categories must now involve a marked impairment in order for the individual to be deemed catastrophic. This too will make it much more difficult for someone with psychological injuries to now meet the test. So the future, where is this headed? Right now, there really is no case law that has emanated from the License Appeal Tribunal of any big significance. So it really remains to be seen how this new test will be analyzed by the License Appeal Tribunal. But right now, the bottom line is that the focus is on functional outcome and how someone recovers. And two, it is now much more difficult to be deemed catastrophic. Now, I want to talk to you about some procedural issues with respect to whole person impairment, that 55% test. One of the things that is required on the OCF 19 application for catastrophic determination is for the insured person to have waited until 3 years have passed from the date of the collision. And this is really to ensure that the individual has reached maximum medical recovery and that there's not likely to be any further healing. The only exception to this requirement would be that if a physician confirms that the insured person's condition is unlikely to improve to less than 55%. So the physician, in essence, needs to be able to say that the impairment suffered at the time of the application is a permanent impairment, such that the individual is entitled to be deemed catastrophic without waiting for the 2 years to expire. Now, in order to be deemed catastrophic, the insured has to complete that OCF 19 application for catastrophic determination. It is signed by either a physician or a neuropsychologist. Now, that is a restriction in the accident benefits that no one else can complete the form. Section 45 of the SABS indicates that in order to determine if someone is catastrophically impaired, an assessment shall be conducted only by a physician, but it does indicate that that physician may be assisted by such other regulated health professionals as he or she reasonably requires. So that's what allows for an occupational therapist, for example, to do an assessment as part of the assessment process. And if the impairment is a traumatic brain injury, the assessment or examination may also be conducted by a neuropsychologist who, again, may be assisted by whatever regulated health professional he or she may reasonably require. So once the assessments are done, an application for determination of catastrophic impairment, that OCF 19 is to be submitted. Within 10 days of receiving the OCF 19 application, the insurance company is required to give the insured person either notice that they have approved the catastrophic determination or a notice that they require a number of assessments under Section 44 of the SABS to confirm the catastrophic designation. Once an OCF 19 is filed, it allows for the attendant care benefit to continue. Now, remember that for non-catastrophic claimants, they are only entitled to attendant care for 2 years after the collision. And so once an application for catastrophic designation is made, the insurance company is required to continue the attendant care benefits until the insurer makes their determination on the catastrophic application. So that would allow for the benefits to continue throughout the assessment process. The other thing is that there is an allowance for the payment of arrears. So if the insured person is ultimately determined to have sustained a catastrophic impairment as a result of the accident, the insured person is entitled to payment of all expenses incurred before the date of the determination. So, if they ran out of money, let's say they exhausted their $65,000 in medical benefits and continued to pay for treatment while they waited to be deemed catastrophic, they are entitled to recover all of those costs once they are deemed to suffer a catastrophic impairment. So, that would include their physiotherapy or their psychological counseling. It also includes their mileage. Because remember, if they are non-catastrophic, there is a 50-kilometer deductible for their mileage. If they are subsequently deemed catastrophic, the insurer has to go back and pay them out all of those 50-kilometer deductibles that were withheld. Once the individual is deemed catastrophic, the individual would then have access to a case manager that is only available for catastrophic claimants. And the cost of that case manager would come out of those medical rehab limits. They are then eligible as well for attendant care benefits up to $6,000 a month. Those attendant care benefits and their med rehab would continue for life, subject to the policy limit of that $1 million. They also then have the opportunity to re-elect their income benefit and change it to the caregiver benefit if they choose to do so. And they would then have access to the housekeeping benefit. So once someone is deemed catastrophic, there is an analysis of what previously took place on the file that will need to be done to ensure that the insured person receives everything that was previously withheld. The next thing that I would like to talk about is home modifications. Section 16, subsection 3, Roman numeral 1 of the SABS provides for home modifications as part of the rehab benefit. And it states this: home modifications and home devices, including communication aids to accommodate the needs of the insured person, or the purchase of a new home, if it is more reasonable to purchase a new home, is available under the SABS. So, think of the situation where, somebody is paralyzed and they now need a wheelchair accessible home. So the SABs allow for the insurance company to either modify the home to make it wheelchair accessible, or if it's more reasonable, i.e. more cost advantageous, the insurance company could purchase a new accessible home for the individual. So this benefit, while it is available to everyone, is typically used by catastrophic claimants, primarily because of the significant cost associated with it. Now, subsection 4C does place some limits on what the insurance company can spend with respect to home modifications. So the insurer is not obligated to pay for the purchase of a new home in excess of the value of the renovations to the insured's existing home. And so what this means is that the insurer needs to determine the cost to renovate the home, as well as the cost to purchase a new home, if that is what the individual wants to do. And the insurer's exposure, though, is limited to the cost of the renovations. So basically, the upper limit for what the insurance company has to pay is the cost to renovate the existing home. Now, keep in mind, though, the insured does not automatically get this money. The insured still has to prove that it is not more reasonable to purchase a new home. It is basically the lesser of the two amounts that is to be paid. So here's how it works. The insurer must first assess the cost to renovate the home the individual had at the time of the collision. And that's important because if the individual moved subsequent to the collision, the insurer still has to assess the home that existed at the time of the collision. That case I talked to you about with my baby who was catastrophically injured when I put the picture of the van on the screen at the beginning of the year, in her case, they resided in Connecticut at the time of the collision. They subsequently returned to Chatham and remained there subsequent to the collision. But the insurer had to send an assessor all the way to Chatham to assess the renovations that would be required on the new home. Once you get that cost, that then sets the cap for the maximum the insurer is required to pay. So if, for example, it would cost $400,000, as you can see in the example on the screen, to renovate the home, that is the upper limit that the insurance company would have to pay. Now, if, however, the cost to purchase a new accessible home is only $250, then the insurer only needs to pay that $50,000, because it is the lesser of those two amounts that the insurance company is required to pay. So if you look at the question at the bottom of the screen, what if the cost to purchase the new home is $700,000? And this is typically what we see, where it's more expensive to purchase a new home than it is to renovate the existing home, but it's still typically better to purchase the new home for someone who's going to need this home for a long time, right? Rather than renovating an older home. So if the cost to renovate the existing home is $400, but the cost to purchase a new home is $700, all that the insurer would have to pay is the $400,000 to renovate the existing home. The remaining $300,000 is something that the insured person would have to come up with on their own, either through their tort claim or other assets or a mortgage, that sort of thing. But the SABS insurer only has to pay the lesser of the cost to renovate or the cost to purchase. Before I move on to this slide, let me just tell you one more thing about home modifications. There is a limit in section 16, subsection 4B, which reads that the insurer is not liable to pay for expenses incurred to renovate the home if the renovations are only for the purpose of giving the insured person access to areas of the home that were not needed previously for ordinary living. So for example, if the insured never did laundry and the laundry facilities are in the basement, the insurance company is not required to renovate the home to give the insured access to the basement. The insurance company is only required to do renovations or pay for renovations that would give the insured person access to areas of the home previously used. Okay, so moving on, in addition to home modifications, the SABs also allow for vehicle modifications. This is found in section 16 as well. So 16 subsection 3 subsection J provides for modifications to a vehicle as part of the rehabilitation benefit. So this would be, where let's say the insured person has an amputation and needs an accessible vehicle, or if they are confined to a wheelchair and they need an accessible vehicle for that purpose. So, think of the situation where, one of the insured's legs are amputated and they need hand controls added to the steering wheel, that sort of thing. So vehicle modifications are to be provided to accommodate the needs of the insured person, or alternatively, similar to home modification, to purchase a new vehicle if it is more reasonable to purchase a new vehicle than to modify the existing one. And section 16, subsection 4, D and E places limits on these vehicle modification benefits. So the insurer first is not liable to pay for expenses incurred to purchase or modify a vehicle that are incurred within 5 years of the last expense. So you can only get a new or modified vehicle every 5 years. And that was a big issue in the case involving the baby that I have, where they did need a wheelchair accessible vehicle. Their first vehicle was purchased when the baby was quite young, but as she grew older, they required a larger vehicle, and they were required to wait until the 5-year mark to be able to get the wheelchair accessible van that they ultimately needed. The second limitation on the vehicle modification expenses is a monetary limit. So the insurance company is not required to pay for the purchase of a new vehicle in excess of the amount by which the cost of the new vehicle exceeds the trade-in value of the existing vehicle. So the insured person doesn't get to keep the existing vehicle and then get a free vehicle from the insurance company. They do have to trade in the vehicle, or at least give the insurance company credit for the trade-in value of the vehicle. And the insurance company only pays the amount over and above that trade-in value. So, let's look at the example on the slide. In this situation, the cost to modify the vehicle was $60,000. The cost to purchase a new accessible vehicle was $40,000. And the trade-in value of the pre-collision vehicle was $15,000. So, with this example, what is the insurance company required to pay here? So we know from the exemptions that the insurance company gets credit for the trade-in value. We also know that they are only required to pay the lesser of the cost to modify versus the cost to purchase. So basically what they're going to do here is pay for the $40,000 less the $15,000 trade-in value. So they will get credit for that $15,000, such that at the end of the day, the insurance company will only have had to pay $25,000. Now, let's move away from catastrophic impairment and talk about the interplay between tort claims and statutory accident benefit claims. Because as we've repeatedly discussed, these claims are very much intertwined. The compensation that an auto victim receives is really a combination of what is available to them through their SAVS carrier and what is available in tort. So I've listed on the screen seven items that address the interplay between tort and SAVS claims. And throughout the balance of the lecture, we will go through these 7 items. So let's start with number 1, no double recovery. And I've mentioned this frequently throughout the class. In auto claims, the expectation is that there will be no double recovery or duplication of payments. So someone can't recover income loss through SAVS and expect to also get 100% of their income loss in tort. The tort insurer will get a credit for any SAVS payments that are made, thereby reducing the tort insurer's exposure. So if, for example, the individual receives, say, $200 in income replacement benefits per week, the tort insurer will pay $200 less per week in income loss damages. And so a person cannot recover more than what the individual is entitled to put them in the place they would have been in but for the collision. The second point that I want to talk about is the matching principle and the concept of silos. So there's a recent Court of Appeal decision which really impacts this. It's the Cadeau decision, which I will talk about in a minute. But prior to Cadeau, the way that these collateral benefit deductions to prevent double recovery were dealt with was through a matching principle. So you deducted apples from apples and oranges from oranges. So as an example, income benefits would be deducted from income loss. Medical benefits would be deducted from medical care, and attendant care benefits would be deducted from attendant care damages, that sort of thing. And so let me give you an example. So let's look at an example using the matching principle that existed prior to the Cadeau decision. And so in this example, you can see it in the chart. And if you look on the left-hand side, the numbers there represent the SAB settlement that was affected for all future benefits. So medical benefits of $50,000, attendant care benefits of $100,000, and income replacement benefits of $75,000. And so what happens is you go through the tort trial and the judge and jury would give the tortfeasor credit for any accident benefit settlement amounts. So when the tort damages are awarded, let's look at this example on the right-hand side of the screen. Future care costs consisting solely of medical benefits in the amount of $100,000 were awarded, and no attendant care benefits were awarded. And then future income loss of $50,000 was awarded. So the question here is, how much will the tort insurer have to pay in future care costs? And so let's look at the future care costs. And it was an apples for apples approach. And so let's start with the medical benefits. $100,000 was awarded in tort, $50,000 was received in the SAB settlement. So the tortfeasor will get credit for that $50,000 and would therefore only pay $50,000 for medical benefits. Because no attendant care benefits were awarded in tort, the tortfeasor would not have gotten credit for the $100,000 in settlement of the SABs. So in essence, for future care, all that the tortfeasor would pay is $50,000. And then the next question is, how much would the tort insurer have to pay with respect to income loss? So again, the tortfeasor gets credit for the SAB settlement. There was $75,000 paid and an award of $50,000. So, $50,000 minus $75,000 puts the insured person in the hole. It does not mean the insured person has to pay some of the money back to the tortfeasor's insurer. It just means that no money would be paid to the insured person on account of his or her income loss. So even though on its face this appears to be a $150,000 tort judgment, it really turns into a $50,000 tort judgment, being only the future care costs awarded over and above the medical benefits. So this was what we have dealt with for years and years and years, and it was always apples from apples, oranges from oranges. This, however, recently changed, or at least has been very much muddied by the Cadeau decision, which went all the way to the Court of Appeal. And my understanding is that it is in the process of being appealed to the Supreme Court of Canada. In the Cadeau case, which is a 2018 Ontario Court of Appeal decision, the appeal dealt with the deduction of an award of SABs that was paid before trial from the tort damages. And what the court looked at is, how are SABs to be matched to tort damages for deduction purposes? Is it to be an apples to apples approach, or is it to be this new silo approach? And what is meant by the silo approach is really that benefits should be lumped into silos. And the trial judge adopted this silo approach, holding that all the healthcare benefits should be deducted from the jury's award of healthcare costs. So in the example that I just showed you, for example, the amounts awarded for attendant care and the amounts received from the SAB settlement for attendant care and for medical benefits should be deducted from any award for care costs. So that would, in effect, in that particular case, indicate that the insurance company for the tortfeasor has to pay nothing because it would have a $150,000 credit to the $50,000 paid. And so the issue here is it this apples to apples approach, or do we just lump all the similar benefits together and deduct them in totality from a tort award? And what the Court of Appeal found is really that they agreed with the trial judge and that the silo approach should apply. And consequently, they found the trial judge did not err in deducting the SABs received for both medical and rehab benefits and attendant care benefits from any healthcare recovery. And you can see on the screen, should the three different statutory categories of SABs, income replacements, health benefits, and other pecuniary benefits be regarded as silos? And the Court of Appeal said yes, they should. And they basically devised the SABs into these three silos. And you can see how they're structured on the screen. The income replacement benefit silo would include all income replacement benefits deducted from all damages for income loss, regardless of whether they apply to past, present, or future. And what had previously happened is if a jury awarded future income loss, the tortfeasor would not get credit for the past income benefits paid. Whereas with this silo approach, it appears that they would. They also created a health silo, which would include all the medical, the rehabilitation, and the attendant care benefits, and that those benefits are all to be deducted from any damages for medical, rehab, and attendant care, again, regardless of whether or not they are for past or future benefits. And then the third silo that they created is other pecuniary loss, where they lumped all other pecuniary loss into this third silo and indicated that they should be deducted from the jury's award. So this would include benefits for housekeeping loss, lost educational benefits, that sort of thing. The court found that there is no basis for making a temporal distinction between past and future SABs, and that they should be combined in each silo before the deduction. And you can see here the Court of Appeals reasoning. What they found is that the policy rationale that supported the strict matching approach under the former statutory scheme is no longer, in their view, applicable under the current legislative regime. In their view, the silo approach, based on those three broad categories, should apply both to the deduction as well as the assignment of the SABs. And remember, future benefits, if they continue to be ongoing, they would typically be dealt with by way of a trust or an assignment. And what the court held is that this silo approach should similarly apply to them as well. And so, this is a relatively new issue. It has not yet heard its last day. With the appeal to the Supreme Court of Canada, things may still change on this, but it will certainly be interesting to see how the Supreme Court of Canada deals with this particular issue. So going back to the list of issues that I wanted to deal with respect to the interplay, we've dealt with no double recovery, we've dealt with the matching principle. Let's talk next about the timing issue with respect to settlement. So because the interplay is so important, it really raises an issue as, which one can you settle first, or should you settle both at the same time? Tort cases, as we know, are often settled on a lump sum basis. Accident benefit cases can also be settled on a lump sum basis, or they may continue on with periodic payments for as long as the individual is entitled to them. So whether you're representing the plaintiff or defense, you need to take this into consideration and decide, do you want both parties together to try to settle both the tort and the SABS claim at the same time? Often insurance companies will want that because it will result in a larger dollar amount to the insured person, and that larger amount will be more difficult to turn down. Insured persons will sometimes want that, but other times, they may not know what is to come in the SABS claim, and they may want to preserve their right to later apply for catastrophic determination if their condition worsens. So there may be reasons why the parties do not want both present at the same time. The fourth thing that I wanted to talk about is settlement strategies. And, there are strategies that both sides tend to take here. And this really relates to that timing issue with respect to settlement. The plaintiff, for the most part, is going to want an all-inclusive settlement of benefits. They want the certainty of knowing how much money they're going to get, and knowing that they do not have to continually submit forms or fight the insurance company or risk termination of the benefits in the future. They want certainty. And so often what happens is the SABS carrier will contact them and want to make a lump sum payment to close their file. Now, when you do this, you don't want to undersettle the file because you do have an obligation to the tortfeasor with respect to their collateral benefit credit. And so there's a lot of considerations that need to come into play here. Section 267.8 of the Insurance Act includes some procedural rules for settling cases. And what it indicates is that with respect to the tort case, the plaintiff has an obligation to apply for collateral benefits and make him or herself reasonably available for any examinations. The plaintiff, and we've talked about this, is also precluded from settling the collateral benefit in bad faith. And remember, those benefits are deducted whether they are received or available. If the benefit was available and the insured person jeopardized his or her entitlement to it, it can still be deducted. So in essence, these SABS claims cannot be settled in bad faith. And bad faith implies the conscious doing of a wrong, so a dishonest act, trying to cheat the tortfeasor, that sort of thing. Now, if a tort insurer wants to allege that the SABS claim, for example, was settled in bad faith and still get credit to the additional benefits, the tortfeasor's insurer has the onus of proving that bad faith. They must demonstrate the intention to deprive the other party of the right of deduction. Now, bad faith is obviously, a very difficult thing for an insurance company to prove. But even still, in my view, plaintiff counsel need to be very careful when discussing settlement of a SABS claim before a tort claim is settled. They need to make sure that this individual is fully protected both in tort and SABS. Now, if you do settle the SABS claim in advance of the tort claim, it's important that the settlement be reasonable, that it certainly pass the smell test, and then the settlement will also need to be broken down in a way that the collateral benefit deduction can later be determined. And when you're representing plaintiffs, you obviously want to break down that settlement in the most advantageous way to the injured accident victim. Now, the next issue that I want to talk about is number 5, the AB offset and contributory negligence. So this is really dealing with the collateral deduction for accident benefits, but how you do that deduction when the plaintiff in tort has been found to be contributory negligent. Now, we've already discussed the principles of contributory negligence. So we talked, for example, about the seatbelt defense, and we talked about how they, in particular, impact auto cases. And so we know that the plaintiff's damages are going to be reduced to the extent by which the plaintiff is contributory negligent. So if you look at the example on the screen, if John is 50% contributory negligent, we know that his damages will be reduced by 50%. The issue when you're dealing with collateral benefits is really what comes first, the chicken or the egg. So, do we take John's damages, which in this case for income loss is $1,000, do the collateral deduction and subtract the $500 in income replacement benefits, and then reduce the amount by 50% for contrib? Or do we do it in the reverse, where we take his damages of $1,000, take the 50% reduction, and then subtract the collateral benefits? And when you look at the two options, you can see that the first would enable John to still receive $250, whereas the latter option would result in no payment going to John. So I'm sure you can all guess which of the two is the appropriate way to go. So unfortunately, the way this goes is not in the favor of the insured person. Section 267.8, subsection 8, requires that the reductions for collateral benefits be made after any apportionment for damages required by Section 3 of the Negligence Act. So what that means is that you first have to reduce the damages for contributory negligence. So in this case, John's $1,000 would be reduced by 50% and turn into $500. You then would reduce the remaining number by the collateral benefits that were received. And because John received $500 in income benefits, he will receive 0 in tort. This really does reduce what a plaintiff is otherwise entitled to. Loss transfer is the sixth thing that I would like to talk about. And what loss transfer really does is it permits an insurer who is paying accident benefits to be indemnified by another insurance company for all or part of the accident benefits it has to pay. It basically means that your own insurer may not be responsible to pay your SABS benefits in certain circumstances. The at-fault party, for example's insurance company, may have to pay your accident benefits. And so what would happen in that situation is you would claim your benefits through your own insurance company, but the at-fault party in these specific circumstances, their insurer would reimburse your insurance company. This entitlement to indemnification is called loss transfer because the loss is in essence transferred to another insurer. And loss transfer was introduced in 1990 in order to address the cost implications from moving away from a fully tort-based system to one that includes the SABs. What the legislature was trying to do was balance the cost of providing accident benefits with respect to certain classes of vehicles. And so, some vehicles are quite frankly more prone to cause injury. So if you're riding on a motorcycle and you're hit by a vehicle, you are more likely to have more severe injuries than if you were in a car. Similarly, if you are struck by a semi-truck, you are more likely to have greater injuries. And so it's these classes of people where it could be quite costly to obtain insurance to ride a motorcycle or to obtain insurance to drive a semi-truck. And because the cost could be so high, the legislature introduced this concept of loss transfer to transfer that cost to the at-fault party. Now, loss transfer really balances out the cost of providing compensation by shifting the cost from, for example, insurers of motorcycles to insurers of other classes of vehicles. If motorcyclist insurers, for example, were to pay for all of the accident benefits for their insureds, the cost to get insurance to ride a motorcycle would be through the roof. So by allowing loss transfer, it means that the motorcyclist insurer is not always responsible to pay all of the SABs the motorcyclist who's injured requires. Loss transfer is outlined in Section 275 of the Insurance Act. And what it in essence does is permit the indemnification in certain circumstances. This is really the starting point for loss transfer. So the question then becomes, when does loss transfer apply? What circumstances? And Section 9 of Regulation 664 sets out the particular circumstances where indemnification is owed. And there's really three situations where it would apply. The first is motorcycles or collisions involving motorcycles. The second is collisions involving heavy commercial vehicles. So think of transport truck, for example. And the third is situations involving motorized snowmobiles. And we are going to examine each of these situations. So let's start with dealing with loss transfer as it applies in motorcycle cases and cases involving motorized snowmobiles, because the legal test is the same with respect to motorcycles and these motorized snowmobiles. And what we're really looking at here is the fact that if you're operating a motorcycle or you're operating a snowmobile, the chances of you being more greatly hurt are certainly enhanced if you are hit by a vehicle. So there's a 5-part test that must be met for loss transfer to apply in these particular cases. First and foremost, the accident must involve an individual insured by a motorcycle or a motorized snowmobile policy. So the motorcycle in question must be insured under a policy of insurance, or the motorized snowmobile must be insured under a policy of insurance. The second thing that's required is that the accident must involve another class of vehicle. So if we have an accident involving two motorcyclists, loss transfer wouldn't apply. We need to have an accident that involves a motorcyclist and another class of vehicle, whether it be a car or a truck or something other than a motorcycle or a motorized snowmobile. The third thing that is required is that the motorcycle must have been involved in the accident. So it's not enough to say, I also have a motorcycle policy. The motorcycle has to be part of the accident. Number 4, there must be some degree of fault attributed to the other vehicle. And when the insurance companies attribute fault, they use what's called the fault determination rules. And what those rules do is they set out the degree to which each party is at fault. It doesn't mean that the, at fault party actually caused the collision, but the rules set out all the various types of circumstances that could arise and the percentage of fault that is to be assigned to each party under the Insurance Act. So there must be some degree of fault per those rules attributed to the other vehicle, so not on the motorcyclist or the motorized snowmobile operator. And the fifth thing that is required is the insurer of the motorcycle or the motorized snowmobile must be the insurance company that paid the SABs. And provided all 5 of those things are met, the insurer of the other vehicle who has a portion of responsibility is required to indemnify the insurer of the motorcycle or snowmobile that paid the statutory accident benefits. And the indemnification is made based on the degree of each party's fault. So if the other vehicle is 50% at fault, the other vehicle would indemnify the insurer of the motorcycle that paid the SABs for 50% of the SABs paid. The motorcyclist insurer would still have to pay the remaining 50%. So the motorcyclist and the snowmobile's insurer only receives indemnification to the extent that the other vehicle is at fault. So let's look at an example to see how it does apply. And remember, the test is the same for motorized snowmobiles and motorcycles. So, although this example deals with a motorcycle, it would be the same circumstances if we were dealing with a motorized snowmobile. So in this example, we have Rick Larchmont, I can't even pronounce the name. He is operating a motorcycle. He is insured, and his motorcycle is insured with Mirage Mutual Automobile Insurance Company, and he is, per those fault determination rules, 10% at fault for the accident. Then we have Thad Patterson. He is insured through Revolving Door Assurance Company. He is operating a different class of vehicles. He's in a convertible. He is found to be 90% at fault for the accident. So the question here is, which insurer is responsible for Rick's SABs, and how do these loss transfer rules apply? Now, what Rick will do after the accident is he will make a claim for statutory accident benefits to his own insurance company. And his own insurance company will pay him the accident benefit SABs. They will, however, also look to Thad's insurance company to indemnify them for the SABs paid, and Thad's company will need to pay 90% of Rick's SABs that are paid by Mirage Mutual. And the reason this is the case is because all 5 aspects of the test are met in this situation, and loss transfer will apply. So number 1, the accident must involve an individual insured by a motorcycle policy. Rick's motorcycle is insured through Mirage Mutual, so we do have a motorcycle policy involved. Number 2, the accident must involve another class of vehicle. That would be Thad's car in this particular case. Number 3, the motorcycle must have been involved in the accident. Yes, it was here. Number 4, some degree of fault must be attributed to the other vehicle. And in this case, Thad is held to be 90% at fault per those fault determination rules. Now, if it were different, and let's say Rick was 100% at fault and Thad was not at fault at all, this aspect of the test would not be met. Similarly, if it were reversed and Thad was only 10% at fault, Thad's insurer would only have to reimburse Rick's for 10% of the SABs paid. And the 5th aspect of the test is that the insurer of the motorcycle must have paid the SABs, and here Rick's insurer in fact paid his SABs. So Revolving Door, which is Thad's insurer, will therefore indemnify Mirage Mutual. It doesn't mean that Revolving Door pays the SABs to Rick, or that Rick has to make his application to Revolving Door. Rick still deals only with his own company, and the indemnification is done as between the 2 insurance companies. Rick is not involved in that. Now, the other way that loss transfer can apply is if we are dealing with a heavy commercial vehicle. And this slide sets out the test that applies when a heavy commercial vehicle is involved. So it's a four-step test. Number one, the accident must involve a heavy commercial vehicle. And heavy commercial vehicle is defined as a commercial vehicle with a gross vehicle weight greater than 4,500 kilograms. So what we're dealing with here would typically be large trucks, semi trucks, that sort of thing that operate for commercial purposes. The second thing that is required is that the person injured in the collision must not be claiming SABs under a policy that insures a heavy commercial vehicle. So we must have the person claiming SABs under a different policy of insurance. The third thing required is that some degree of fault must be attributed to the heavy commercial vehicle, and that the insurer of the other vehicle must have paid the SABs. So in this case, it's sort of the reverse of the motorcycle situation. If a heavy commercial vehicle is involved in an accident, that heavy commercial vehicle, more likely than not, is going to cause greater injury. And so because of that, loss transfer would apply to require the heavy commercial vehicles insurer to reimburse the other vehicle for the SADs to the extent by which the operator of the heavy commercial vehicle is at fault. So let's look at an example of this as well. So here we have a situation, we've got Vicki Kavanaugh driving in her little red sports car. She's insured with Mirage Mutual Automobile Insurance Company. We then have Edward Smalls, who's operating a large commercial truck. And this is based on an actual case. It was actually a truck that was hauling manure, if you can believe that. And so Edward Smalls is found to be 100% at fault. His commercial vehicle, which is in fact a heavy commercial vehicle and exceeds that gross weight of 4,500 kilograms, was insured through a revolving door assurance company. So what's going to end up happening in this case is that Edward Smalls, so first, actually, let me back up. First, Vicki will bring her SABs claim to Mirage Mutual. Mirage Mutual will pay out her SABs claim based on, whatever is reasonable and necessary and all of the benefits for which she's entitled. Mirage Mutual will then make application to Revolving Door to be indemnified for the SABs that it had to pay to Vicki. And Revolving Door is required to indemnify them on the basis of 100% because Edward Smalls is 100% at fault. So let's look at how the test applies in this particular case. So number one, accident involves a heavy commercial vehicle. Yes, we have Mr. Small's truck. Number two, person injured is not claiming SABs under a policy of insurance insuring a heavy commercial vehicle. Yes, Vicki is claiming SABs under the policy that insures her red Corvette. Three, some degree of fault must rest on the driver of the heavy commercial vehicle. Here, that is Edward Smalls. He is 100% at fault. Number four, the insurer of the other vehicle must have paid the SABs, and yes, Mirage Mutual paid Vicki her SABs. So in this case, Revolving Door, which is the insurer of the heavy commercial truck, is required to indemnify Mirage Mutual, that's Vicki's insurer, for the SABs it paid to Vicki. Now, there's a few other issues to consider when dealing with loss transfer. And the first is found in Section 275, subsection 3 of the Insurance Act. And what it indicates is that there is no indemnity in respect to the first $2,000 of statutory accident benefits paid. That really creates a $2,000 deductible. And so there will be no indemnity for the first $2,000. The insurer required to provide indemnity will pay everything over and above that $2,000. Loss transfer is also now available for all SABs paid. Previously, there were certain SABs that it did not apply to, but it does now apply to cost of assessments conducted under the schedule, the cost of case management services, and all expenses that are covered by the SABs schedule. The only exception to the SABs that need to be indemnified is interest and punitive damages or special awards. And the reason these things are excluded is because if the insurer that's required to pay the benefits in the first instance fails to do so in a timely manner and has to pay interest, that should not be the other insurer's responsibility. Or if the insurer who pays the benefits in the first instance does so in bad faith and attracts a special award, that too should not be the other insurer's responsibility. There is an expectation that the insurer will administer the benefits in good faith and in a timely manner in accordance with the SABs. The other thing that's important here is that the insurer that's required to indemnify the other for the SABs is not entitled to dispute the SABs payments that were made. The insurer in the first instance has the right to adjust the claim as they see fit. The only thing that the other insurer can, however, do is that they can dispute the reasonableness of the payment and argue that the payment should not have been made. I had an issue where we were trying to deal with a housing situation, and the insurer's numbers were different than my expert's numbers. And it became difficult to resolve it without getting the loss transfer insurer involved and or going to a LAT hearing and having the matter resolved. Because the insurer paying the benefit in the first instance wanted to make sure that it would be fully reimbursed by the loss transfer insurer. Now, it remains the responsibility of the first party insurer, so the one that is responsible in the first instance to pay the benefits. So in the Vicky example, it would be Vicky's insurer. So it is that insurer's responsibility to ensure the benefits are paid correctly and that they are paid promptly. The individual, as I mentioned, has no idea that there is another insurance company involved. The two insurers deal with themselves separately from the individual. And if any disputes arise as between the two insurance companies, they are to arbitrate those disputes. So that's in essence loss transfer. I hope that makes sense. It can be a complicated issue. But basically what it does is it transfers the ultimate responsibility to pay the SABs to the at-fault party in these particular situations. So let's now talk about the seventh item that I wanted to discuss, and this is the admissibility of expert reports. So in most cases, SABs carriers will send their insureds to a number of medical assessments, and these are called independent examinations. We talked about them being required under Section 44 of the SABs. The assessor in these situations is to be an independent assessor and is to assess the insured's entitlement to the specific benefit. So if, for example, my client applies for income replacement benefits, the insurance company could send them for an assessment to see if they are entitled to the benefit or meet the legal test. Similarly, with treatment plans for medical and rehab care, the insurer could send the client to an assessment to see if the plan is reasonable and necessary. So what you end up with in most of these cases is a number of medical reports and assessments in the SABS file. And these medical reports and assessments may or may not be useful in the tort claim. Sometimes these assessments can even carry more weight in a courtroom than the party's own expert reports because, like I said, they are supposed to be prepared for an independent purpose. They were not hired guns hired by either the plaintiffs or the defense. The question here, though, is whether they are really independent, as the doctor is certainly selected by the SABS carrier, who is, quite frankly, trying to avoid payment. But the reality is that they are at least independent from both the plaintiff and defendant in a tort action. Then, in addition to these SABS reports, you also get reports generated throughout the tort claim. So tort defendants are entitled to send the plaintiffs for medical assessments per the rules of civil procedure, and plaintiffs will similarly go for their own medical assessments in order to obtain their own expert reports. And so you end up with this combination of tort and SABS reports. And so the question here is, how are these dealt with in LAT hearings as well as in tort trials? And are the tort medical assessment reports admissible in AB LAT hearings? And are the AB medical assessments admissible in tort trials? Now, for those of you who took torts, I assume you probably talked about Rule 53 and the need for an expert in civil litigation to sign an acknowledgement of the expert's duty, where they acknowledge that the report was prepared independently of either party and that they recognize their duty here is to the court, not to one of the two parties. With the assessments that happen in the SABS file, there would be no Form 53 that was signed by the assessor. And so this raised issues of whether or not these SABS medical reports could be used in tort trials and whether or not the author of those reports could give expert evidence in the courts. Now, prior to 2010, plaintiffs and defendants would, in essence, pick and choose which SAB reports they wanted to rely on at a tort trial. And it would vary depending on the conclusions. If the report was supportive to the plaintiffs would use it. If the report was supportive to the defendants would use it. Then in 2010, when the new rules of civil procedure came into force, and that's where Rule 53 was created, requiring this acknowledgement, there were a number of challenges, specifically with the technical requirement of this Form 53 to be created. And there was a whole host of cases that kind of went all over the map and really muddied the waters here as to what should happen. There were some cases that said these SABS experts couldn't testify as experts and they couldn't give expert evidence. Others said they could give some evidence, but not other evidence. So it just became very, very confusing. This all, however, came to a head with the case of Westerhoff and G, which I believe is in your USB materials. And this is really the leading case on this particular issue. It was an appeal to the divisional court from the trial judge's ruling that was then subsequently appealed to the Court of Appeal. And at the lower court, Justice Lederer reviewed the state of the law and the distinction created between treating and litigation opinions. Because that's what sort of happened in the case law is they said if they didn't formally do an assessment for the tort claim and complete the Form 53, they would be classified as a treating opinion and would not be able to give expert evidence such as a diagnosis and a prognosis. And so it created this huge drama in civil litigation, because if we couldn't use these reports that were created throughout the lifetime of the claim, how then would we be able to do these trials in a cost-effective manner? Because all of the parties would have to hire their own experts to give the very opinion that had previously been paid for. And so what Justice Lederer said is that there was an important distinction, and that distinction is not in the role or the involvement of the witness, but in the type of evidence sought to be admitted. If it is opinion evidence, Justice Lederer held that compliance with Rule 53 is required, but if it is just factual evidence, it is not required. Now, he went on to say that treating doctors, however, do stand apart. So think about, the family doctor who wants to provide his diagnosis. Does he need to complete this Form 53 and prepare a formal report, or could he come into trial and testify to that diagnosis? And what Justice Lederer said is that these doctors may give evidence of their observations to the plaintiff and their description of the treatment provided, and that this is factual evidence, not opinion evidence. These doctors do not need to be qualified as an expert to give this evidence, nor do they need to comply with Rule 53. But what he went on to say, and this is where a lot of the confusion lied, is that these doctors cannot offer opinions as to the cause of the injury, its pathology, or its prognosis unless they met the requirements of Rule 53. So this, in essence, meant that these family doctors would be prohibited from giving a diagnosis, for example. And as you know, when you go into the doctors yourselves, they always have to diagnose your condition to determine what treatment to prescribe. And so to not allow a family doctor to testify as to the diagnosis he or she formed would really create chaos in civil litigation. So when Westerhoff was appealed to the Court of Appeal, the appeal decision was released in March of 2015. There were a number of interveners in the case, including the Ontario Trial Lawyers Association, the Medical Malpractice Group, the Canadian Defence Lawyers Association, the Advocates Society, and others. And this was really a very important issue in civil litigation, with all of the parties really coming together to say, we need to make this make sense, and we need this to be cost effective as well. And so it was really an appeal from two cases. One was Westerhoff and the other was McCallum. And both cases were tried before a judge and a jury. And in each case, the defendant admitted liability at trial. So the only issue related to whether the accident caused the plaintiff's injuries and damages. So the issue here was for the Court of Appeal was whether Rule 53 applies only to experts engaged by or on behalf of a party to provide opinion evidence, or whether it applies more broadly to all witnesses with special expertise who give opinion evidence. And this broader group would include treating physicians and experts retained by non-parties, such as the SABS insurer. Now, in this case, Mr. Westerhoff argued that Rule 53 applies solely to litigation experts, and that which are experts engaged by or on behalf of a party. So if I go out and I hire an expert to provide an assessment. And Mr. Westerhoff argued that treating doctors should not have to comply with Rule 53. It would be too costly and cumbersome to make them comply. Now, I've spoken to some of the counsel who were present at the Court of Appeal, and what they said is the Court of Appeal basically said to them before they gave argument that we think this would be too cumbersome, and kind of agreed with the approach of Westerhoff and asked for guidance as to how treating experts should be treated in the litigation so that they can set out some rules with respect to this to make it more workable for all the parties, and much more cost effective. And so ultimately, what they held was that these non participant experts, so experts that were not strictly hired for the tort litigation, are entitled to give opinion evidence without complying with Rule 53. And here's a quote from the court where they said, "I conclude that a witness with special skill, knowledge, training, or experience who has not been engaged by or on behalf of a party to the litigation may give opinion evidence for the truth of its contents without complying with Rule 53.03, so long as the opinion evidence to be given is based on the witness's observation of or participation in the events at issue." So that would apply, for example, to a family doctor who's treating the plaintiff. And so long as the witness formed the opinion to be given as part of the ordinary exercise of his or her skill, knowledge, training, and experience while participating in the event. So, I mean, in essence, what's happening here is they're allowing the SABS experts to testify, and they're allowing the treating experts, such as family doctors, to testify without the need to formally comply with Rule 53. And the court went on to say witnesses, albeit ones with expertise, testifying to opinions formed during their involvement in a matter do not come within this description. They are not engaged by a party to form their opinions, and they do not form their opinions for the purpose of litigation. So that would apply to those family doctors. Their opinions on the diagnosis were not formed because of the litigation. They were formed as part of treating the individual. The court went on to say, as such, they are not engaged by or on behalf of a party. A party does not engage an expert to provide opinion evidence simply by calling the expert to testify about an opinion the expert has already formed. And lastly, the court said, if participant experts or non-party experts also proffer opinion evidence extending beyond the limits described, they must comply with Rule 53 with respect to those portions of their opinion. So I can call a family member, or sorry, a family doctor to testify at trial and talk about the diagnosis and talk about the treatment that they administered. But if they didn't form an opinion on the individual's prognosis as part of the normal course, I would require a Rule 53 form to deal with any opinion with respect to prognosis. But where the doctor is coming in and just testifying as to the opinions formed during the normal course of his or her work, there is no Form 53 required. So this final quote from Westerhoff really describes the reasoning for the court's decision, where the court indicated that unlike an expert witness that is hired to provide opinion evidence with respect to the lawsuit, these participant experts and non-party experts are not testifying because they are paid a fee to do so or to write a report. Rather, they're testifying because they were involved in the underlying events, and generally they've already documented their opinions in their notes or their summaries. So it's okay for them to go into court and testify, even if it is an expert opinion, if it relates to what's already in their notes or their summaries. Requiring them to comply with Rule 53 can only add to the cost of the litigation, create the possibility of delay because of potential difficulties in obtaining compliant reports, and add unnecessarily to the workload of the persons not expecting to write these reports. Because what was happening before this case came out is if I wanted to call a family doctor, I had to have them write a formal expert report, which I would need to pay for. And they had to file a Form 53. And so it really did increase the cost and complexity of civil litigation. So the Court of Appeal really did a good thing here in Westerhoff by simplifying the process and allowing for these experts to still give evidence. So the final thing that I do want to leave you with is this Rick Mercer video, and I've given you the link as well as you can play it from the PowerPoint that I previously circulated. So watch it on your own. It is a little bit of comedy relief in the midst of everything that we are all dealing with, and I thought you might enjoy it. It is a very short video clip.
Hi, we're your insurance brokers.
Many of our clients are upset to learn that premiums will be going up.
But this year we had to pay out a lot of money on insurance claims.
We didn't see that coming.
No, we didn't. We thought that you would just give us money every month, every year, forever and ever.
But some of you, Alberta, you're ruining it for everybody.
And screwing up our business model. Show them our business model.
We take money from you.
That's our business model. It was pretty straightforward.
But if you try to take money from us, we are going to have to take even more money from you.
Simple math.
But as your insurance brokers, we also know that not everyone can afford increased rates.
That's why we're also innovating new services.
Like our no-claim insurance.
No-claim insurance allows you to pay us a fixed premium every month, every year that will never increase.
If you agree to never file an insurance claim. Ever.
Like never.
You just keep giving us money.
Your insurance brokers.
You're in cold hands.
Good hands.
Good and cold hands.
Your insurance brokers. Don't worry, we're always going to make money.
So that, in essence, concludes the course. I want to thank all of you for being such a wonderful class. I appreciate your attendance throughout the year, as well as the questions that you had, and I'm sure all of the hard work that all of you have done. I wish you all well, both with the examination for the course, as well as in your future endeavors, particularly for those of you who are about to go on to articling and bar exams and ultimately into practice. One of the things that I do offer to all of my students is, when you do get out there and practice, whether it be this coming year or the following year, if you find yourself dealing with an auto case and you want to pick someone's brain or you've got some questions, feel free to email me or call me at my office. I have no problem helping young counsel deal with these cases. I mean, whether you're on the plaintiff or the defense side, I want to make sure that you can avoid law pro and certainly can do a good job for your clients. So if you do have any questions, feel free to call me. I'm always happy to help out former students. Otherwise, like I said before, I will be available as you prepare for the examination. Please email me any questions you have or email me your telephone number and I will certainly call you. I do want to make sure that all of you are fully prepared for the examination, particularly given that this is such a unique situation we all find ourselves in. So if you do need anything, please do not hesitate to let me know. Otherwise, I wish you all the best, and I hope you all stay healthy and take care of yourselves. Thank you so much.